Welcome to the third episode of 154 in Defense. Today we are honored to have with us Mr. Malak Bhatt, who is advocate on record before the Supreme Court of India and founder of NM Law Chambers. He has vast experience in commercial litigation, white collar crime litigation, and insolvency laws. He also advises and represents clients in international commercial arbitrations and domestic arbitrations. Welcome, sir. I'm honored to have you, and thank you for joining in and taking out the time.
Thanks a lot, Prakar. Thanks for having me.
So today we are diving into a complex and often debated issue, the conundrum between the Insolvency and Bankruptcy Code and Prevention of Money Laundering Act. Now, these two laws, while crucial in their own right, sometimes find themselves at odds, creating significant challenges for businesses, legal practitioners, and regulators. Now, the IBC is designed to help distressed companies resolve their financial troubles quickly and efficiently, aiming to either revive the business or liquidate, for that matter, while maximizing assets value for creditors. Now, on the other hand, the PMLA focuses on combating money laundering by empowering authorities to investigate financial crimes, freeze assets, and confiscate proceeds of crime. But here is where the conundrum arises. What happens when a company undergoing insolvency under the IBC is also under scrutiny for money laundering under the PMLA? Can the IBC's goal of resolution proceed smoothly if the PMLA freezes the very assets needed for that resolution? So my first question is, can you discuss in detail how do the objectives of Insolvency and Bankruptcy Code and PMLA come into conflict, particularly in relation to attachment and management of property during such insolvency proceedings?
So, so in fact, because one issue which we at least keep grappling very often as someone who practices both on the insolvency and the white collar crime side, uh, we are faced with this issue very often, especially either from the promoter side or even from the bank side as to what exactly would be the resolution. So you asked actually the first question is right where it hurts the most as to the objective of these acts. Now, if you go down and see the legislative history of both these statutes, the purpose of both the acts are not at contradistinction or are not at loggerheads. When the PMLA was brought into effect in 2002 and effectively so promulgated in 2002 but brought into effect only subsequently in 2005 and then by an amendment of 2009, the primary object of the PMLA was to arrest any dissipation of monies or dissipation of assets which have been obtained by way of a illegal activity. So the very premise of the PMLA investigation is that there has to be what is called what we commonly know as a predicate offense, and any proceed of crime which is generated out of that predicate offense should then be arrested so that that does not lead to further percolation or dissemination such that the taint of that money goes and becomes untainted. So the idea of the powers of the ED, especially under the PMLA, as far as attachments and subsequently confiscation are concerned, is to trace back to see that companies, and especially talking in terms of companies, that companies which have otherwise, taken money from banks or for that matter, have legitimate sources of monies which have come to them by any illegal activities, either of siphoning or of diversion, do not convert that money into, any form of proceed of crime, either in their own hands or in the hands of some other companies or subsidiaries. And then that money slowly trickles down into their own web of systems where it's not traceable for the real purpose for which it was taken. The idea on the other, so the idea is very simple, that the idea is to keep the money or keep the assets attached or to keep the assets identifiable such that it does not lead to a situation where the proceed of crime is actually fructified in the hands of the accused. On the other hand, in 2016, when the IBC was brought in, the approach of the IBC mainly was to try and negate what all had gone wrong with the DRTs, especially while dealing with the RDB, the DRT Act, and the SARFAESI, because the process of resolution under both these acts had practically stifled. There was no resolution that was taken place. And in terms of the approach that India had tried till now, we had always been a more debtor-centric approach. So even if you look at a resolution framework, which is placed either at the BIFER or the IFER stage, the company's old creditor debt, the management used to stay in control and they used to propose a resolution framework. The IBC make that drastic shift to making the entire resolution framework a creditor centric approach. So the people, the financial lenders who have actually lost the money, if they feel that this is actually a good business in practically the wrong hands, so let us take over those assets, give it to someone who may be better equipped to practically deal with this situation. And that's where the entire CRP process takes place. So you have a resolution applicant who is otherwise not connected, who comes in and says, look, I know the asset value is 100 rupees. The debt of on that 100 rupees is 120 rupees because of banks loans going default. I'm here, I'm ready to pay you 80 rupees for this, but you give me these assets, I'll work around these assets. And only when the plan is seen to be financial, and which is why the plan is never only dealing with issues of just monetary value that the bank has. They also have to check what is very critical in the plan is financial viability of the plan, and the fact that the resolution plan proposes how the company is to be taken forward. So you basically pick up a good asset and hand it over to a good management, which was in so-called terms in the hands of a bad management. So the idea is that you have to give that person who's coming in a clean, unencumbered asset so that he can work on the very plan that he has worked around. Now, where do these two acts kind of merge? Is if the asset which otherwise is already under investigation and is attached, are you really giving the person who's coming in practically like a white knight as a resolution applicant to say that he's ready to take for the company and keep him in a loom of darkness whether your asset will actually be cleanly given to you in your hands or not? And that's where both these acts kind of merge while dealing with the same very asset, but from two different perspectives. So while ED is right in their own perspective that, look, ultimately what has happened is that 100 rupees was taken from the bank by saying that I will use this money by way of, say, working capital. But what the promoter actually has done is he has taken this money out into his own account and has gone ahead and bought a house for himself. Now, this house is subsequently given to a second bank by way of a mortgage. So it again becomes part of the company's assets. While you're dealing with CIRP, you will say, look, this is an asset which the resolution applicant really needs to work out because this asset he'll either monetize or he'll use this asset as part of his resolution plan. The ED says, no, this is the asset which is actually ill-gotten because it has been used for some other purpose than what the loan was given to. Therefore, it definitely amounts to a criminal activity. And you cannot allow a criminal activity to be washed away only because a subsequent statute has come in. And that's where the schism lies. So we'll take this forward once the conversation goes in. But this is where the two acts, despite dealing with the same property from two different objectives, kind of merge and otherwise contradistinct itself when it comes to the resolution framework under the IBC.
Okay. While I was reading judgments, which dealt with this conundrum of IBC and PMLA, mostly there were three legal principles on which, the courts were moving forward while deciding the tussle between them. First one was harmonious construction, and the second one was the idea that later law overrides the earlier one, and the third one was doctrine of larger public interest. Now, what's your take on this, and which one of these principles you think is best efficient principle to, resolve the conflict?
So see, as far as the subsequent law is concerned, that principle is fairly clear. And even if one is to compare the actual statute, there is an overriding clause in the PMLA also, and there's an overriding clause in IBC also. So you have section 65 read with 71 on one hand, you have section 238 of the IBC. The IBC obviously being a later statute, so the statutory presumption is that the lawmakers while making IBC knew about the fact that the PMLA is in existence. But the question that that theory or that proposition of law does not answer is that you are considering a theoretical situation as if the plan is going to work itself out. Right now, from the ED's perspective or from the PMLA standpoint, let's assume a situation where the person who is actually bidding for the company, he gets the company with all its assets, and let's assume for a minute that the ED attachment is directed to be lifted. What happens in situations where the resolution applicant himself is acting in connivance with the old promoters? or a situation where the resolution applicant actually fails to deliver the plan and the plan actually gets scuttled. So ultimately leading to a situation where the plan fails implementation and goes into liquidation. By this time, you would have handed over the asset back to someone without an ED attachment, and ultimately a so-called proceed of crime would have been taken out from the supervision of the ED. So the application of the principle as such is not, obviously not disputable, but factual scenarios in each case kind of make that principle slightly more nuanced, or at least water down the the overall impact. I would think out of the three, a larger public interest argument is obviously much more tailor-made for the purpose of IBC. And the reason I'm saying so is that when this issue had arisen for the first time in 2017-18, when ED's attachments were being upheld by courts, the first ever judgment which dealt with this issue was by the Delhi High Court in the case of Prakash Industries and then Rajiv Chakravarti, where they said that very well, there is a moratorium in place under Section 14 once the CIRP comes in. But ED's power of this was not a question of whether the attachment will go away once the plan is approved, etc. The question in Rajiv Chakravarti was whether the ED's power to confirm an attachment or to attach the property itself are alive during the time the CIRP is ongoing. And the court actually, after looking at larger public interest, and read with the fact that this is a subsequent statute, said that these two acts are not in contradistinction. So till the time the objects are not, at loggerheads, the ED's power to attach property and for the adjudicating authority's power to confirm the property will still remain. And if that is to remain, what ultimately the courts are looking at is to maintain public interest at both spheres. So from a jurisdictional perspective of ensuring that India meets its and sorry, just to step back a bit, the PMLA was actually promulgated for the purpose of India to meet its international obligation under the FATF convention. So we obviously have a regular annual reporting requirement where we have to report to them as to the number of cases that have come up, etc. It's a different argument that the whole purpose of bringing in PMLA at that stage in 2002, 2005 was to curtail drug terrorism and drug and terrorism money, and not to go into economic offenses. But that be that as it may, the legislative wisdom thought that it's prudent to extend it, especially in India where there were large scale bank frauds that were happening. But if you go back to that objective, then while a CIRP is ongoing, for the ED to keep an attachment power sustained and for the adjudicating authority to confirm that attachment is in consonance with as far as the PMLA's objective is concerned, because that is nothing but you're not being dispossessed. The title doesn't go away. It is just ED telling you that this asset cannot be sold further till the time the investigation is ongoing, because we have identified this property to be a part of the procedure of crime where we have an apprehension that this will be dissipated. Does that power dwindle down when the CIRP ends? There is when the first time the question arose as to what happens if the attachment is to stay and practically speaking, the CIRP is to continue. Now, if I'm a resolution applicant and while the CIRP is ongoing, I'm bidding for a project where, say, there are 5 properties and 2 properties suddenly get attached by the ED, I have no bandwidth, or I don't have any anticipation of whether that attachment will go or not. Will I really go and bid for the company? The answer obviously will be a clear no. Why will I take that risk? And that risk was for the first time highlighted when the legislature felt that these two acts, while dealing with different topics, are not going in consonance with each other because the effective implementation of the IBC is getting stopped. If you have an asset which is attached and which remains attached during CIRP, then the effectiveness of someone coming in to bid for a company who's otherwise independent but is not in a position to get clarity on the attachment goes away. And this is the entire reason why in 2019 Section 32A was brought in. So we'll go into 32A, but if you look at the object and reasons of 32A, out of the 3 principles that you stated, 32A was brought in from the perspective of larger public interest, that effectively, and if you look at it from, I'll just take one more minute here, but if you look at it from a bank fraud perspective, let's span it how it happens, and we'll go into other separate cases uh, subsequently. But 90% of the cases that we have seen where ED attachments are there are all cases where banks are involved. So what happens is The ED attaches a property which is otherwise mortgaged to the bank and which is shown to be a proceed of crime because that is a property which has been either derived out of or has been generated out of an activity which the promoter has created by his illegal acts. So in the ED's attachment scenario, it is actually a property which is in the bank's hand. That very property goes into the CIRP process, and that very property is then bid for by the resolution applicant, and he takes it over to say that very well, now that property being worth 100 rupees, I will give you a haircut of 30 rupees. I'll take it for 70 rupees. I'll monetize it. Out of that 70, I'll give the bank 60 rupees. In both the scenarios, the victim of of the entire fraud exercise, be it in the CIRP or in the attachment proceedings, is the bank who is now getting recouped for his money. So ultimately, in this scenario, if the resolution applicant is given that protection, it is actually for the benefit of the actual victim of the case in the PMLA investigation, which is the lender. And from that perspective, the object and reason says that if you do not give what they termed for the first time in the object and reason as a clean slate to the company, then the resolution applicant's effectiveness of implementing his resolution plan or to monetize the assets which are otherwise under attachment will substantially reduce, and that will impact the resolution framework of the IBC in general. So that was the outlook, and which is why out of the three, the third principle is what really stood forth for the courts and for the legislature.
Okay. So since you refer to the judgment of Rajiv Chakravarti, so it has been applauded for basically ending the debate between PMLA and IBC. And what it basically stated that moratorium would not prevent authorities under PMLA to attach property. And as attachment, it also said that Section 5 is not, the attachment under Section 5 of PMLA is not permanent and just an interim measure. Now, by the authorities to prevent the corporate debtor from being alienated, from preventing the property from getting alienated. Now, the provisional attachment order is just an interim measure, and it will not vest rights of the CD to central government as mandated under Section 9 of the PMLA. Now, the resolution process of the CD will continue as usual under the provisions of IBC, and ED will become the owner of property in question. Basically, if uh, if this is just an interim measure, which the ED is under Section 5, if this is just an interim measure preventing CD from getting alienated, do, do you really think that what if the property gets confirmed, like this attachment gets confirmed while the resolution process is still going on? Rajesh
Right. So
Chakravarti did not highlight that. So I would want you to, actually give your thoughts on this, because I don't think so. This has actually ended this debate.
right, no, so in fact, as far as ED's power to confirm attachment during CIRP is concerned, is actually also subsequently dealt with by the Delhi High Court in a subsequent case regarding Bhushan Steel. Now, I'll give you the exact citation once we go further into it. But in both the scenarios, let's understand first, on just without looking at the IBC, the pure purpose of why Section 5 and Section 8 are there. So if you look at the entire level of argumentation that took place in Vijay Madanlal Chaudhary when the vires of the PMLA was upheld. And fortunately, I had an occasion in that matter to assist Mr. Rodgi on the aspect of Section 5 and Section 8. The final finding of the court on that issue is very helpful to understand the purpose of Section 5 and 8. Now, otherwise speaking, the powers of the ED to provisionally attach assets come in only when the predicate offense charge sheet is filed. Because only when the charge sheet is filed can you understand what the actual predicate offense is for you to start looking at what asset that predicate offense has really generated. But there is a proviso. The proviso says in exceptional circumstances, if you feel that the asset is in the likelihood of being dissipated, then the ED, even before the charge sheet and the predicate offense is filed, can go and attach the property. In most cases, the ED does not wait. It goes and attaches the property. Now, between the provisional attachment, which has to be continued for 180 days, and the confirmation which has to happen within the one in that 180-day period by the adjudicating authority, The general trend was that the moment confirmation takes place, ED would immediately send you a notice saying that kindly grant possession to us of this property and vacate the premises in 10 days. On the 10th, they'll come and they'll lock the premises. And this issue was highlighted before the Supreme Court that it is on this factual aspect that ED has effectively taken on the role of being the adjudicator itself by deciding while the trial is not even seen the light of day that the property is a proceed of crime. In such a scenario, the Supreme Court said that yes, they have powers, but that power of attachment and confirmation does not take away title. So the only purpose of an attachment and a confirmation is to identify, to trace, and to restrict any further dissipation of the property. Would this impact the CIRP? The answer is yes and no. Yes, because from a practical perspective, if a property is attached and if you don't know whether this property will ultimately be, released to me, the resolution applicants or the number of resolution applicants which would come in will obviously reduce. No, because even if a property is attached during CIRP, the possession does not go with the ED. The title does not go to the ED. The vesting of that property cannot be given to the ED till the time the person whose hands the property is in is convicted, because that's the only power under Section 8(5) of confiscation. And confiscation of the property can only happen once the conviction takes place. So during CIRP, an attachment or a confirmation taking place does not really impact the nature of the property. Practically, it may so, but legally speaking, it does not. And the rationale where Rajiv Chakravarti comes in, the court has said that you are looking at from a situation that the resolution takes place, right? That let's say a third person comes in, buys the property, and he says, "What about me? I am nowhere connected to the uh, promoter. Why should I suffer the harm of the property?" See a situation where the resolution does not happen, and the company through the COC or through the RP is ultimately put into liquidation. Now, once a company goes into liquidation, and if you are selling it, obviously the first step in liquidation now also is that you have to sell it as a going concern, which means it has to get the same benefits. But if it's not sold as a going concern, and the property is ultimately to be either sold by stake sales, also by piecemeal sale of each property by the liquidator, or by a scheme which the promoter himself can promote or can promulgate. In such a scenarios, ED's right will take precedence because ED has identified this property as a proceed of crime. So therefore, to obviate a situation where if the attachment is not there, see, till the time the CRP is ongoing, there's a moratorium in place. So one can understand that while the moratorium is in place, anyway, the property can still be maintained and can be protected. Once the liquidation starts, there's no moratorium. So if the attachment is not there, then ED's right over the property will go, and that may also lead to a risk of the property being dissipated. And this is the argument that Rajiv Chakravarti has really taken to balance this two out as to what happens to someone who is a bidder in the resolution process and who is and from an ED perspective in the liquidation, 32A was brought in. So if you see 32A, 32A actually says it has two parts. One, it says that as far as criminal prosecution is concerned, the resolution applicant or its directors cannot, or the company cannot face any further action as far as criminal prosecution is concerned. And any action taken on the property for the corporate debtor will end the day resolution plan is approved by the COC, by the NCLT, or on liquidation. So on liquidation also, the liquidator gets the property in his hand free of all encumbrances from the ED so that he can sell this property as a going concern without any embargo of the attachment. But in that period, to ensure that the asset or the procedure of crime so-called remains identifiable, the power of the attachment has still been sustained.
Okay. So just a doubt regarding this. If what if so what would happen if the ED was to, so ED has already temporarily attached this property from being alienated, and Section 32A was brought in, so that there is no a certain kind of fear among the resolution bidders that what happens if ED attaches the property after we become the successful resolution applicant. That fear would still be there, right? Because ED has temporarily attached the property. What if they convict that old management, the directors and the other management? under
Right.
885 of PMLA, they would attach the property saying that we have already convicted the management and therefore, we are attaching the property. So don't you think that fear would still be there among the applicants?
Yeah. So in fact, it's a risk not not unknown to law, because despite the fact that 32A is in place, practically we have seen cases where despite 32A's protection, the ED attachment doesn't really go away. And I'll tell you how practically this has an impact on the plan. See, most cases where the company is planning to monetize the plan by selling the asset or by actually capitalizing the asset. So making, say, if there's a factory, then you would basically take a loan on that factory by bringing in more funds through some other lender, and then you will try and pay the banks who are part of the COC. Or you will try and sell an asset ultimately and pay the banks as part of the first tranche. The comfort that resolution applicants thought they would get is from 32A, that I don't need to, take any further action. If my plan deals with this situation and my plan has an express condition that the ED attachment goes, then I am sorted, right? Practically, we've seen plans also where the NCLT as part of its order records the fact that, yes, once the plan is approved, then because of 32A, ED attachment goes. Now comes the conundrum. Which court is the person supposed to go as the SRA to get the actual ED attachment removed? So when you had a situation where once the plan is approved, the person actually goes and tries to sell the property, the sub registrar will not take the sale on record saying that the ED attachment is there. Now there are two or three forums that one generally typically thinks of. One, you go to PMLAT and you tell the PMLAT that, look, now this attachment has to go because the adjudicating authority's confirmation has to be set aside in light of 32A. The process of the PMLAT unfortunately is so long that it may actually trample upon the timelines that you propose in your plan. The other issue that has subsequently arisen now, thankfully, we had a judgment from the Bombay High Court in the case of Shiv Charan, which gave pure, robust implementation mechanism to 32A. The judgment by a DB was so sacrosanct and said that, look, if you don't give this clean state, there is no purpose of having the IBC. Shut it if you want, but don't do this where the person has to run from pillar to post to get his attachment removed. This was, in fact, one of those cases where, against the NCLT order, the ED had gone to the High Court in 227 saying that the jurisdiction of the ED is not there, of the NCLT is not there to pass such orders. And the High Court, in so many terms, held that no, once the plan is approved, the language of 32A has to be given effect to, and therefore the NCLT, in its wisdom and during approval of the plan, can pass an order to remove the ED attachment. This issue was pending for the Supreme Court because ED took this up in appeal to the Supreme Court as far as Shiv Charan's case was concerned. 2 weeks back, we've had the judgment in the case of JSW, Kalyani Transco, where a specific finding has unfortunately been rendered, and I would feel it's an absolutely incorrect decision, where the Supreme Court has said that neither the NCLT nor the NCLAT have any power to remove the ED attachment because they are ED is under a separate statutory framework. There are remedies and mechanisms provided under the PMLA, and NCLT, being a statutory body framed under the Companies Act, does not have the power to deal with it. So again, the resolution applicant is left in a state of stare decisis, where neither can he go to NCLT and CLAT now till the time this Supreme Court judgment is pending. If he goes to a High Court in a writ, probably some High Courts may entertain, some may not, depending on the mindset of the judge. But some High Courts may very well end up saying that, look, this is a process under the regulatory framework. You may go under the regulatory framework. And obviously, if you end up going to PMLAT, then it will take its own time. I don't even know if it will get removed or not, but it will take its own time. So yes, to answer your question, there is a lot of current um, dichotomy as far as the resolution applicant himself is concerned of where to go, and therefore, if this power of attachment so is kept even during the CRP period, it will have a cascading impact on the resolution process. So the what's the solution then? The solution can be two of, I mean, the two ways to go about this is, number one, and this is what Mr. Rodgi had actually suggested recently when we had a youth discussion along with the Insolvency Law Academy, that either you give an automatic no objection or removal of attachments the moment the plan is approved. Let this person not be made to run from court to pillar to post, or try and go to three or four different courts. Put it as part of the statutory framework that once the plan is approved and strict conditions are followed to ensure that neither is the resolution applicant working at the behest of the old promoter, or that the plan actually is sacrosanct and will ensure that the property is being given to someone who will otherwise going to work around the resolution of the plan, the implementation of the plan. Then the attachment process has to stop at that very point in time. Option two is that you do this at the very start of the CIRP, because in any case, as far as properties belonging to the company are concerned, you have conditions laid down in Section 14, which provide a complete moratorium and protection to the assets of the corporate debtor. If required, Section 14 may be amended to make it more robust to ensure that no transactions impact the assets of the corporate debtor while their CIRP is ongoing. But in the current scenario, if you ask me, you are right. Rajiv Chakravarti, and so the judgment I was talking about was in the case of ED versus SBI by NCLAT, where NCLAT has also held the same thing, that the adjudicating authority's power to confirm attachment does not go away during moratorium under Section 14(1)(d), because it's not really, and the interpretation that they have given is it's not a proceeding against the company, nor is it enforcement of security interest. But yes, from a factual standpoint and from an implementation practical standpoint, it will have an impact. So that requires some clarity.
Okay. So as of now, if the successful resolution applicant can go to PMLAT, right? If the resolution was to take place to remove the attachment. Now, what happens if the CIRP is ongoing, the moratorium is in place, and this provisional attachment actually becomes, is confirmed by the AA? What happens at that particular time? Or if the trial is over, let's say, for that matter, if just a hypothetical situation, it won't happen in a period of 2 to 3 months, but what would happen in that case? Would ED take the higher pedestal?
Well, if you come to look at it, then uh, okay, it's interesting to look at it, because the situation has not really arisen till now, because we've not seen any ED investigations culminate into trials where the company is ultimately convicted. But it will have to be seen as to the stage at which the conviction takes place. Now, if the conviction has taken place prior to the CIRP starting, then it's a clear answer that that property gets acquired by the central government. So it goes outside the territory of Section 18 of the IBC. So it's no longer the asset of the corporate debtor. As far as the asset of the corporate debtor is concerned, it already has moved out to, and the title has changed. That property is now vesting with the central government, obviously with a right to the bank concerned with who has the mortgage to go and apply to the concerned trial court to get the property back as the victim. And typically we've seen that happen. So in Kingfisher's case, in Nirav Modi's case, a lot of the banks have actually moved the trial court and sought restitution of the properties which were mortgaged to them, saying that they were the actual victim. So that obviously that's an easier part. Now, if once the proceeding against the company, the CIRP against the corporate debtor starts, practically speaking, the conviction of the company anyway cannot take place because of the Section 14 moratorium. So you will not see a situation where once the CIRP starts, a conviction takes place, because the proceeding anyway could not have continued. Thankfully, you have two judgments now of Honorable Delhi High Court and Supreme Court saying that if a proceeding does actually continue against the company during CIRP, then the proceeding is non-est. It will be considered to be void ab initio. So even if the company is ultimately to be convicted during the moratorium ongoing, then that judgment ultimately will be had to be bad in law. But let's, for the sake of your question, and let's for the sake of argument, let's consider that the conviction does take place. Because of the moratorium being in place and the language of Section 14(1)(d), the confiscation cannot take place because the property now during the CRP's the ongoing CRP cannot change hands. So it will still remain to be part of the corporate debtor's assets under the mechanism of the RP under Section 18 and will become part of the resolution process. So it will, if any conviction happens during CIRP or post CIRP, I don't see a situation changing where the property can not be given to the resolution applicant. Obviously, it will be a hard drawn battle for him to fight the ED, and I'm sure the ED will take this issue to every court possible. But uh, I don't see the confiscation really hurting once the CIRP starts.
I'll just tell you my opinion, and just correct me like if you think I'm wrong. So ED attaches assets under PMLA to prevent their alienation and secure eventual restitution to victims of financial crime. Now, even in this case, the management responsible for the proceeds of crime is anyway going to be prosecuted. They are not given clean chit. Now, when assets are already under EBC, now when assets are already subjected to resolution, which aims to revive business and repay creditors, right? So, given that broadly PMLA and IBC share this common restitution goal, ED's attachment powers, don't you think the attachment powers of ED should be exercised with caution in cases where IBC proceedings are going or like ongoing? Uh, there must be certain kind of coordination between ED and insolvency authorities which can ensure that the recovery is not stalled and the public interest is best served. So what do you think in like
No, no, I absolutely agree with you on every line, letter, and spirit of what you said. And um, I, in fact, would go a step further to say that once a company goes into CIRP, if the ED really has necessary protocols and manuals, SOPs in place, so you must be aware that when the issue regarding their arrests came up, and the Supreme Court reprimanded them for the manner of their arresting powers, where people are getting arrested at 2 a.m. and 3 a.m. The ED actually internally came out with a set of guidelines with for their officers as to how to and in the manner in which the arrest is to be carried forward, which includes all the issues concerning providing grounds of arrest, providing the memo of arrest, providing reasons to believe, etc. I feel similar situation has to take place where within the ED there has to be a set of protocols set in place where I don't really see the need for the ED to go and attach any property till the time the CIRP is ongoing, because the moratorium in every possible manner protects that asset. Yes, as far as the promoter is concerned, there is no embargo on them. They are very welcome to go and attach all the assets that the promoter has generated or the promoter has derived from the company, because those assets will obviously be, subject matter of dissipation, or there will be imminent threat of diversion of those properties. But as far as the corporate debtor is concerned, yes, the ultimate beneficiaries, if the conviction is to take place, will be the financial lenders. In the IBC, the ultimate beneficiaries are going to be the financial lenders. There is no requirement for that additional burden of attachment to be placed just to create a terror around the resolution process, because that is actually hampering the resolution. Ultimately, even if the ED's attachment is to, get confirmed and confiscation to take place, that property is going to end up being with the bank. So why stop the bank from getting fruits of that property in the IBC process? I completely agree with you that there has to be some mechanism where both the ministries can work together and work this out. And in fact, interestingly, I'll tell you, when the judgment of Shiv Charan was challenged before the Supreme Court, on the first hearing before Justice Oak, Mr. Tushar Mehta, as the General Solicitor General, had made that statement that at an interministerial group level, some discussions are taking place on how to streamline these two functionaries on attachment and on coordination with the IBBI. So for the implementation of the IBC, but since the matter leave was granted in the matter, it's not seen the light of day. And somewhere someday, I think that answer will come through as to what coordination has happened. But yes, time is what will ultimately decide this. But I agree with you in full force that there is actually need for a lot of coordination to ensure that the resolution framework does not get completely hampered.
so according to you, Rajiv Chakravarti needs to be revised because it said that the ED's attachment won't get affected by moratorium.
Well, in the current legal framework, I will not say it needs to be revised for the simple reason that it is sound as far as the legal principle is concerned. So as I'd gone back to you, and let's just take 30 seconds to recollect. The purpose of the attachment was very different from the purpose of the resolution process. The reason why we are seeing this schism is the practical realities in which the attachments are not going. Now, if you have a 32A in place, and if 32A is to be given full vigor to, then I don't see the reason why the NCLT cannot have the power to remove that attachment the day the plan is approved. If that gets revived, if that power is granted, Rajiv Chakravarti is actually sound in law, because that attachment power of the ED is not in contradistinction to the purpose of the IBC, nor does it really hamper the moratorium under Section 14. But if that attachment is to linger on for years, and the resolution applicant is to run from for to three different courts, and ultimately end up being in a situation where if he does not implement his plan in time, he is going to actually face prosecution under Section 74, then yes, Rajiv Chakravarti is bad, because then the purpose of IBC and the purpose of PMLA are definitely at loggerheads. And then you need to come to probably a much more stricter situation where you lay down a law that there should be no attachment at all when the CRP is ongoing. But I believe more than Rajiv Chakravarti, it is the finding in JSW which will have to be probably relooked at by the Supreme Court, because to hold that the NCLT and CLET do not have the power to remove the attachment may definitely be a very, very big thorn in the entire process, because that's the one single forum which deals with every aspect arising out of the CIRP. You had Justice Chandrachud's judgment in Gujarat Urja, which categorically said that any and every issue arising out of the CIRP, be it law or fact, the only jurisdictional forum to deal with this will be the NCLT. Now, while the attachment is by the ED, ultimately it is impact on the assets of the corporate data which are part of the resolution process. I think both of them can be read together and give and the NCLT be given the power, because without that, you are not allowing the IBC to work out itself completely.
So, expanding on that particular argument, there is this section in IBC, Section 60, Clause 5. Now, this
Yes.
non-obstant clause grants exclusive jurisdiction to NCLT over any question of law or fact arising in relation to the resolution process. Now, uh, does this not suggest that the adjudicating authority under the PMLA lacks jurisdiction over assets undergoing CIRP? And how did Supreme Court miss this section in JSW?
So
Or what
in
was their
fact,
interpretation?
their interpretation was in fact slightly on a much more skewed level, I would say, and respectfully so. The and Supreme Court in JSW went on to look at the power, the provisions which formed the NCLT. So they, in fact, instead of looking at Section 60, subsection 5, looked at Section 421 of the Companies Act to see where the Companies Act is actually, where the NCLT is actually formed as a tribunal. And deriving that the logic from that, they said, since you are a body dealing with Companies Act and you have jurisdictionally been given powers of being an adjudicating authority under the IBC, your powers are restricted only to look at issues arising out of Companies Act or IBC, whereas the power of attachment is specifically given under the PMLA of confirmation to the adjudicating authority under Section 5 and 8. What the Supreme Court missed is, as you rightly said, 60 subsection 5 and Gujarat Urja, because in Gujarat Urja, the court was in fact dealing with this very issue, that whether cancellation or interpretation of agreements, power purchase agreement being the agreement in question in that case, would fall for uh, interpretation to in the jurisdiction of the uh, adjudicating authority, the NCLT. And the court actually went ahead and said that, look, it is only in rare cases that you can actually approach the writ court, because the terms of Section 60, subsection 5 are it's a non obstante, and it is very wide. So anything and everything which touches upon the resolution framework or which has an impact on the resolution framework can definitely be tested by the NCLT. And in fact, in this case, more so, you have a statutory provision within 32A2 which deals with this. It is not as if they had to apply equity principles to actually come to a conclusion that the resolution applicant has to be given a clean slate, or for that matter, that the attachment has to be released because it's which theoretically or notionally towards working of the IBC, there is a specific statutory amendment where the legislators have brought in 32A for this very reason. The only authority which can give effect to 32A is the body framed under the IBC, which is the NCLT. There is no other reason for 32A to be given to any other court. Otherwise, this 32A could have actually been added into, for that matter, in the IBC. If this power was to be given to the adjudicating authority or to the PMLAT, you could have had this provision inserted by way of amendment in the PMLA. The reason you inserted it in the IBC shows that you are giving the power to deal with the interpretation of and the application of 32A to the tribunal formed under that very statute. And if that is the case, there is no reason why 65 should not be read to ensure that it is only the NCLT which has the power to deal with removing the attachment and no other body.
So just this one is the last question. So, do you think to end this debate of IBC and PMLA, any matter concerning the assets of corporate debtor during the pendency of CIRP must be dealt exclusively by the NCLT?
So I would rather, in fact, end the debate with three options, and I think each of the three may work out to be uh, one better than the other. Option one would be either a statutory amendment comes into place where this requirement of even going to any court does not arise, and it is statutorily prescribed that the ED attachment lapses the day conditions of 31 read with 32A read with 29A are satisfied. In fact, to that extent, let me just stop here for a minute. And if you look at the language of 32A, 32A actually provides for that safeguard that even if the plan is approved and the management of the corporate debtor changes, only then that protection of removal of the attachment is given. Reason being, if it's an MSME, if the promoter is allowed to bid for the company as an MSME, as we know that under the IBC, the old promoter can take back his company if it's an MSME under the IBC itself. 32A2 has that protection provided that if it's a case where the same management is coming back, then the attachment will not go. Meaning thereby the IBC, the legislative framers were conscious of the fact that we don't want a situation where facing an ED investigation, the old promoter, either surreptitiously himself or while the company is otherwise in CIRP, takes this advantage of bringing the company back into his own fold and then says, look, now the ED attachment goes. So to obviate that risk, the language of 32A itself builds that safeguard that only if the management of the company changes from one hand to the other, are you going to provide this safeguard of the attachment going. So I feel if the resolution framework has to be made more robust, and if India has to be seen as a creditor centric recovery oriented mechanism where companies are actually being resolved, the one of the ways forward is to bring out a statutory amendment to do away with any requirement of going to court. And if that cannot happen, then you come to option two, which is you give NCLT the exclusive power to deal with anything and everything to do with ED attachments as well while the CRP is ongoing. And the third would be, obviously, if these two cannot work, then as we discussed, let there be a protocol in place where ED becomes cautious of attaching assets during CIRP, and either you take away that power during CIRP or you make them cautious that if unless there is a imminent requirement where and there may be situations, we have seen cases where the resolution applicant is actually working at the behest of the promoter, or there is a conspiracy between the RP, the promoter, and the resolution applicant to actually take the company out. In situations like this, if the ED has concrete evidence, I don't feel uh, not giving them that power will have any issue. But as we discussed, these are matters of misuse, and only because there's an imminence of misuse of law cannot be the reason why the law cannot be changed. So then have protocols in place where the ED is made cautious about the fact that if the company is in CIRP, then their hands to that extent should be more tied as compared to dealing with companies which are not under CIRP. So priority one, two, three is according to me are these three. And it is only then can you actually come to a situation where there will be clarity on this issue, because currently and unfortunately because of GSW, we are right now in a very, very bad state of flux.
So, even after the judgments of Shiv Charan, Rajiv Chakravarti, Nitin Jan, we are still not able to create a holistic environment for SRA. He,
Yes, unfortunately so.
okay.
Not right now. And we will have to wait for the Supreme Court to deal with Shiv Charan and to deal with potentially a review or a relook at JSW if it so happens, to ensure that the IBC mechanism is given its true teeth.
So just a follow-up question: why do you think Shiv Charan needs to be reviewed? Because it basically upheld 32A. It
Not Shiv
said
Charan, JSW needs to be reviewed.
okay, okay. All right, sir. Thank you so much for sharing your expertise on such a complex and critical area of law. Your perspective on this, on this contemporary issue related to PMLA and IBC has been truly enlightening. Thank you so much for